Hey, everybody, we will get started here in a few minutes. If you have any questions, please use the chat box. And as soon as our first presenter is on, we'll get started. Okay, everybody, we will go ahead and get started. Thank you all for attending our 2020 virtual ethics seminar. My name is Andy Cole, and I'm the pro bono coordinator over at West Tennessee Legal Services. If you have any questions for the presenters during their presentation, please use the chat box function. I will be monitoring that and asking the presenters during their presentations if you have any questions. If not, Lewis, I believe that I have promoted you to being a panelist. Do you need to share your screen or use the video or anything?
I do need to share my screen.
Okay.
Good afternoon, because I have let me see here.
All right. I'm going to stop my screen share. So now you should have the ability to share your screen.
Okay, let's see here. Let me make this thing. No, hang on, I pressed the wrong button. I don't think everybody wants to see the temperature. Let me see if I can get my PowerPoints started here. There we go. Play. There we go. Now, I just need to.
At the bottom, there's a button that says share screen. You should be able to click on that,
Yeah.
and then click the
One that I want to share. How's that? Can you see it?
Yes, it is up. So you are good to go.
So, good afternoon, everybody, and thank you for joining us. In a little bit of a different. I usually talk about something at this seminar in December that's very mundane. Like last year, I think I talked about encryption and computer security. Lots of times I give an update on legal fees. One year I talked about conflicts of interest. But this year I want to back up a little bit. We've been in the midst of what seems like an axial moment for our country, and it doesn't matter which side you're on, it really doesn't, and I mean that. Those of you who know me will know which side I came down on, but that doesn't matter. What matters is that, to me, what matters about it is that as lawyers, we have somewhat of a duty to our fellow citizens to step forward and step into the breach in times like these when things seem like they're all out of sorts. And I'm going to give you a couple of historical examples this afternoon of people who I think have done that we can take as people that we can look up to as lawyers. But in order to make a little bit of a case for this as an appropriate part of this seminar on ethics update, I read to you from the preamble to the Tennessee Rules of Professional Conduct, comment 7. As a public citizen, a lawyer should seek improvement of the law, access to the legal system, the administration of justice, and the quality of service rendered by the legal profession. As a member of a learned profession, a lawyer should cultivate knowledge of the law beyond its use for clients, employ that knowledge in reform of the law, and work to strengthen legal education. In addition, a lawyer should further the public's understanding of and confidence in the rule of law and the justice system, because legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. A lawyer should be mindful of deficiencies in the administration of justice and of the fact that the poor, and sometimes persons who are not poor, cannot afford adequate legal assistance. Therefore, all lawyers should devote professional time and resources and use civic influence to ensure equal access to our system of justice for all those who, because of economic or social barriers, cannot afford or secure adequate legal counsel. A lawyer should aid the legal profession in pursuing these objectives and should help the bar regulate itself in the public interest. To me, that's part of our responsibility, not something necessarily that we have to go to when we have a potential conflict of interest, not something that we have to consult when we're formulating a fee agreement with a client, not something that we necessarily have to look at in terms of the nuts and bolts of it for drafting and promulgating an advertisement about our services into the public realm. It's something that's nonetheless incumbent upon us as lawyers, and that every once in a while, so if I've done this 10 times, this is the one time I've perhaps talked about it in this way versus something more mundane. some of the time to step back and look at these things from a broader perspective. That can help us as lawyers. It can help our society. Like it or not, and a lot of times people don't like it now, I'll share with you that a very good friend of mine, person I went to college with, that I served in the military alongside, and that I've known, consistently in a very personal way since long ago, 1984, what is that, 36 years ago now. During the, I was having a discussion with this person during the last run up to the election. And we were involved in this discussion with two other people who were close friends of ours over a long course of time. And much to my surprise, the in a way that contained a little bit of venom that got under my skin, the guy, my old friend, said, "He's just a damn lawyer. He thinks he knows everything, and he thinks lawyers ought to rule the world." And that was, maybe I do think that, but for good reason. But it taught me a little bit of a lesson, and that is we have to, in some ways, be insistent, but do a better job of of educating people in a way that doesn't alienate them. And maybe the strongest way that we do that is with our lives as an example. And so that's a little bit of what I wanted to talk about this afternoon. So I started with ex parte merriment because I'm going to finish with ex parte merriment. It's an interesting case. There's the quote from Madison that I always start with. And we're going to ask, in the context of ex parte merriment this afternoon, what does it mean to have a government of laws? There's a guy everybody knows, right? I bet there's nobody on this call this afternoon who doesn't recognize that picture, minus the beard, which he didn't have except for the last 4 years of his life. 5 years of his life, a little girl had written to him. She'd seen him on the train on the way to Washington for his first inauguration. And she had written to him that she thought he would look better with a beard. So he grew that beard. But as a practicing lawyer in Illinois, Lincoln did not have that beard. Everybody, I said over on the left-hand side, knows this lawyer president. But what you may not know about this lawyer president is the story of ex parte merriment. Now, Lincoln was elected at a dangerous time in our country. It was split far more, lest we think we're very divided today. People were divided, and the division had been building across the decade of the 1850s. There was the Compromise of 1850, which attempted to solve the political problem of slavery, and I call it the political problem of slavery because that's to be differentiated in a way from the moral problem of slavery, which was insoluble, and eventually it became insoluble as a political problem. But as a political problem, they tried in 1850 to solve that problem. They tried in 1854 to solve that problem. And Lincoln's great nemesis, rather than Jefferson Davis, for example, I think of Lincoln's great nemesis as another head of a branch of government in the United States of America, rather than the people who made war on the United States of America beginning in April of 1861. And that is Roger Taney, who was the Chief Justice of the Supreme Court. Taney had a long history, brilliant lawyer, just in the same way Lincoln was in many respects. Had served in the cabinet of Andrew Jackson. In the second Jackson administration, Taney, in fact, was the Secretary of the Treasury, and he was Jackson's great advocate in the battle with the Bank of the United States in his, I believe, in his second administration, when that occurred. And Jackson had appointed Taney to the Supreme Court. So he'd been serving since the early 1830s, over 25 years, when the time came that ex parte merriment was decided. Now there's a funny Lincoln story that I included, but I'm already off on the presentation, so I'll skip over it. You'll remember, no doubt, the infamous decision of Chief Justice Taney in Dred Scott versus Sanford, 1857. After the Compromise of 1850, the Kansas-Nebraska Act of 1854, excuse me, there came along the dispute in Dred Scott versus Sanford, which created a constitutional crisis in the United States, because it essentially said that one race of people could never be citizens of the United States. And maybe more than anything, that was a thing that brought Lincoln back into prominence. Lincoln was determined by whatever measure needed to be taken to overturn the Dred Scott decision, because he believed it was not a correct constitutional decision. And he believed that it needed to be undone. And he was, in a way, determined to do that. It's important to remember that Lincoln had gone home in 1849. He only served one term in the U.S. House of Representatives. He was elected in 1848, sworn in January or March 1849, I guess it was then, not January. Sworn in March 1849 and 1847, and served until 1849. He'd gone back home and returned to the private practice of law, where he had a phenomenal business, really. In the decade from 1849 to 1860, Lincoln had built one of the most thriving law practices in Illinois. And he did that with his partner William Herndon in that little two-room office. If any of you have ever been there, on the second floor of that building in downtown Springfield, Illinois, with his what law books he had stacked up in one corner, and his paperwork on a roll top desk. But the problem that had beset the country in 1854, and that had been sort of solved, but not for long, by the Kansas-Nebraska Act, came to the front again in 1857, when Taney, in a 7-2 majority in the Supreme Court, made this terrible decision in Dred Scott, which Lincoln considered such an aberration from the text and spirit of the Constitution, especially read against the background of the Declaration of Independence. So there was a great deal of antagonism between Lincoln and Taney before Lincoln ever came into office. If any of you have ever read the Lincoln-Douglas debates, Lincoln's extended argument in the Lincoln-Douglas debates in 1858, where he was debating Stephen Douglas, trying to win one of the Illinois Senate seats. The Lincoln side of those debates are an extended argument against the validity of Dred Scott versus Sanford, and his statements are a vision, really, of a different way of looking at America, a different way of looking at the Constitution, and a different way of looking at the Declaration of Independence. And so he comes into office with this background of antagonism toward Chief Justice Taney. Now, what happened in ex parte Merriman, there's a man named John Merriman, who is a relatively wealthy Marylander. And for those of you who want to take a short detour into Civil War history, I could talk the rest of the time about it, but I'll refrain from doing that, even though I might enjoy that. Maybe some of you wouldn't. What happened is that Maryland had been a state whose sympathies largely had been with the states that seceded and went into the Confederacy. The institution of slavery was thriving in the state of Maryland, and there were lots of vested interests that were tied to the continuation of slavery in the state of Maryland. And so Washington, D.C., if you stop and think about it just as a geographical fact for a minute, it's a little rough diamond-shaped piece of land on the Potomac River, sandwiched between Northern Virginia and southeastern Maryland. It was in a dangerous spot. Now, Maryland decided not to try to secede from the Union and go with the Confederacy, but there was strong sentiment for the Confederacy in Maryland, especially in the area of Baltimore. And of course, most of the rail lines that ran to Washington, most of the rail lines that could be used to bring troops to Washington, D.C. to protect the national capital after the war started in April, were coming through Baltimore. I don't, for those of you who want to think about it some more, there's a fantastic book. If you'll email me, I'll send you the link on Amazon where you can get it, about Lincoln's trip into Washington when he was to be inaugurated. Pinkerton's detective agency, there was no Secret Service then. Pinkerton's detective agency was engaged to protect Lincoln, keep him from getting killed on his trip from Springfield to Washington. And they had to sneak him through Baltimore at 3 o'clock in the morning because there was a plan to assassinate Lincoln before he was ever inaugurated. And that gives you some kind of idea of what Lincoln was up against. And John Merriman was the leader of a group of people who burned railroad bridges and tore up roads, and generally attempted to interfere with the logistics of getting support from the states of the more distant north to the national capital at Washington, D.C. And so it's hard for us to imagine this now, but in those days, Congress was not constantly in session. We could have a debate, I suppose, for the rest of my hour and Laura and Bruce's time too, about whether or not it's a good thing that Congress was not in session year round like it is now in those days. But Lincoln could not get action by Congress because it was not in session in early 1861 when he was first inaugurated, when these problems arose with getting these troops and supplies to Washington. And so the one clause in the U.S. Constitution about the suspension of the writ of habeas corpus is in Article 1. So by association, Article 1 is the article that talks about establishes Congress. And so many people thought that only Congress could suspend the writ of habeas corpus because that article appears in Article 1, the section appears in Article 1 of the Constitution. And yet, without Congress in session and with a distinct threat to the national capital at Washington, Lincoln had to choose what to do. And so he chose to issue an order suspending the writ of habeas corpus. And for those people who aren't real students of what habeas corpus is, it basically means bring the body, corpus, have the body here. And it's a writ that is that a court can issue that is guarding against government imprisonment of people without just cause. In other words, if the government puts somebody in jail without a sufficient reason, someone related to the person can file a writ of habeas corpus on their behalf, ordering the government to bring that person's body to the courtroom and produce it and show why that person should continue to be held. And so Lincoln suspended the writ of habeas corpus. And what did that mean in practical terms? Well, in particular, in this case, it meant Lincoln sent a unit of the Union Army to arrest John Merriman and take him to none other than the fort in the harbor at Baltimore that was the object of the British bombardment for our national anthem. Oh, say, can you see by the dawn's early light? The flag, the fort where Fort McHenry, where the flag still flew in that poem written by Francis Scott Key about the War of 1812, is where John Merryman was in prison. And Lincoln refused the request of the legislature in Maryland, the request of several people to turn John Merryman loose. And so it happened that Roger Taney was from Maryland, and he was the circuit justice for Maryland. Now that's a little bit different than it is today. Today, the circuit justice for each one of the circuits, I don't know if anybody remembers in the last couple of weeks, but Justice Alito of the U.S. Supreme Court is the circuit justice for the Third Circuit. And so repeatedly over a couple of weeks, petitions for injunctive relief, immediate injunctive relief, were presented to Justice Alito from the Third Circuit regarding voting issues in Pennsylvania. Most of the time he referred those to the full court, but that wasn't what the circuit justice did in those days. In those days, in 1861, the circuit justice actually rode the circuit of which they were the circuit justice and actually held court on that circuit. So the judges of the U.S. Supreme Court were out in the country, not holed up in Washington in a marble building, but they were out in the country riding the circuit and hearing some cases, in addition to their job as the appellate court of last resort. So it happened that Roger Taney was the circuit judge that included Maryland, and he held a hearing about the imprisonment of John Merryman. And in that hearing, they had some proof about where he was held, who was holding him, and what the reason for him being held was. At the end of that, there's a case, an opinion issued by Roger Taney called Ex parte Merryman from May of 1861, in which Taney orders the federal government, the United States government, to produce the body of John Merryman. And this is what I think you probably don't know about Lincoln. And that is that Lincoln steadfastly, consistently, and without ever changing his mind, refused to obey the order of Justice Taney sitting as the circuit judge for the state of Maryland in federal court. John Merryman was not released from custody at Fort McHenry. Taney called the general who was in charge of Fort McHenry back into the courtroom again in Baltimore, excoriated him in front of a courtroom full of people, and once again ordered him to release John Merryman to the court. Again, the Army officers refused to do that. The general who was in charge of Fort McHenry refused to do that on the direct order of Abraham Lincoln. And so what I was guessing probably most people don't know is that you've got this juxtaposition. Here is undoubtedly, I think, the greatest lawyer president in the history of the United States. Maybe or maybe not. Andrew Jackson was a lawyer also. Thomas Jefferson had studied law. John Adams was a lawyer. So maybe making that qualitative judgment, I'm getting a little bit beyond the ken of this seminar, but certainly one of the greatest lawyer presidents, Abraham Lincoln, thumbed his nose at the U.S. Supreme Court in 1861. And I mean literally thumbed his nose. In fact, John Merriman was never released. And in fact, once Congress returned to session, they refused to pass the Congress refused to pass the exact suspension of habeas corpus bill that Lincoln requested, passed a different one. And even then, Lincoln refused to order the release of John Merriman. So set that aside as a bit of context. Here's Abraham Lincoln, the man who had dedicated his life to the law, who had dedicated his life to the practice of law. And here he is telling the Supreme Court, you and whose army are going to come and force me to turn loose John Merriman. Now, so ask yourself in that context, what does it mean to have a government of laws? Well, I want to give you a couple of examples. Here are two guys. That the fellow on the left is John Adams, as you probably know. The fellow on the right is James Donovan, a lawyer at a big so-called white shoe law firm in New York City in the 1950s, in the heyday of the backlash against all things associated with communism in the United States. John Adams, another lawyer president who you may remember undoubtedly as one of the great patriots of the American Revolution, one of the, really John Adams, almost more than Thomas Jefferson, represents the legal and intellectual backbone of the American Revolution. Together, of course, they were insurmountable. And Adams knew that he did not have the rhetorical power of Thomas Jefferson, which is exactly why in 1776 he refused to be the author of the Declaration of Independence, but deferred to Jefferson. But as a practicing lawyer, John Adams is an example that we can hardly afford to overlook. And here's just one instantiation of what I'm talking about. John Adams, this great patriot, this fellow who was one of the leaders, put his life on the line in the American Revolution, was the defender as a lawyer of a British officer and 8 British soldiers after the Boston Massacre in March of 1870. And a little bit of factual background, although I don't have a lot of time to go in it in great detail. What happened was there were British soldiers stationed in Boston in March of 1870. They were in the street, and they, because of a dispute with some local citizens throwing ice balls at them, they eventually shot and killed 4 people in the street in Boston. And they were then put on trial for murder in the colonial court in Boston. John Adams, this person who had already written pamphlets against the British government, who was already in 1770 one of the advocates for American action against what they viewed to be the arbitrary rule of the British government. This man came to the defense of these highly unpopular British soldiers and their officer who had been involved in this shooting in the streets of Boston. Now, I think it's hard to imagine for us. We think that things are rough and tumble right now. And it did look a little rough and tumble at some points during this last political cycle. But we have no concept of what rough and tumble meant. And I'll just give you a little bit of a flavor for that if you, and I'll point you in the direction where you can go. There is a fascinating book called 1774. And again, if you want to learn more about it, you want to look at it in more detail, just email me. My email's at the beginning of that, at the beginning of the slideshow. There's this fascinating book about 1774 that is a record of the really consistent mob violence that occurred in the American colonies in the year of 1774. And it was amazing. Royal officials were dragged from their houses repeatedly. And there's a chronicle of this in that book, and painted with tar and doused with feathers. The houses of royal officials were burned down in the year 1774. People were tied up, royal officials were tied up in stockades and whipped in towns in New England. It is absolutely fascinating the amount of violence that went on in in the early part leading up to the establishment of the American Republic. That's the context in which John Adams took on the defense of these British soldiers. And he represented them, what do we call it? Zealously. He made an argument, and eventually he obtained a partial acquittal. No one was acquitted of murder, and the numbers have gone out of my head right now. But all of the British soldiers were acquitted of the crime of murder, and all but I believe one of them were acquitted of any crime whatsoever. But it's an example for us. What does it mean to have a government of laws? The first thing to put into that calculus, that analysis of what it means to have a government of laws, is that you've got lawyers who are willing to undertake this kind of representation. John Adams put his entire fortune and his reputation, and as you can see by looking at what happened just 3 or 4 years later, he put his physical safety at risk by taking an unpopular position in March 1770 in Boston. This guy is James Donovan, who is another, in my opinion, another American hero. Now think about this. He comes into the context where we're talking about representing an accused Soviet spy, a guy named Colonel Rudolph Abel, in the midst of the communist Red Scare, the communist hysteria that took place in the 1950s, McCarthyism and all that. You think about. There was violence then against people who were unwilling to conform to what people thought they should be. He had worked at Nuremberg as a deputy prosecutor, and he represented this Soviet spy who really was a Soviet spy. The episode with Colonel Abel was not some figment of somebody's imagination or some whipped up thing that came about as a result of McCarthyism. Rudolph Abel, which was not his real name, but I'm saying Rudolph Abel because that's what he called himself, and it's so much easier to say than his long Russian name that I've chosen to just call him Rudolph Abel. Now, if I were in person or if I could hear you all, I would be wondering why you weren't laughing, but I guess everybody else is muted. And so I'm not going to feel too self-conscious about the fact that my jokes are going out into the ether without any response whatsoever. Rudolph Abel was captured, and all these big Wall Street firms, the federal district judge for the Southern District of New York asked these people to help out, and they refused to do so. Donovan goes and represents Abel. He challenged the search that led to Abel's arrest all the way to the U.S. Supreme Court. He then continues to represent Abel, and just as an interesting aside, if you want to look at Gary Powers' book, Operation Overflight, where he compare the trial that Powers got in the Soviet Union to the trial that Abel got in the United States. But think about this in context. Just like John Adams, James Donovan was willing to undertake the representation of this person that was hated by everybody, that was the object of the most vicious feelings of antagonism that existed during that time. In the 1950s, there was no one who was detested more than the communists in the United States of America. In the 13 British colonies in 1770s, among the populace, there was no one who was detested more, who they thought was more of a danger to their safety and well-being than the British Army, which represented what many Americans thought of as the arbitrary power of the British Crown. So you've got these two guys here who I think are represent something out of this comment, which is it's the idea that there's a value to the process, right? Yes, we could have dragged Rudolph Abel out in the street and shot him. And you know what? At the end of the day, Rudolph Abel was guilty. He really was a Soviet spy. If you've seen Bridge of Spies, you know a little bit about this because there was a movie maybe 4 or 5 years ago about James Donovan. But I commend you, if you like that, to look at Donovan's book, Strangers on a Bridge, which talks in a lot more detail about the trial. The reason I think that's important is because it demonstrates to us that process matters, even when the people are guilty, even when ultimately there's no metaphysical question about whether or not the person violated whatever law it was that they're accused of violating. On the other hand, sometimes it does matter because John Adams, as was demonstrated, represented people who ultimately had not violated the law in the way that they were accused of. The two ends of that spectrum are a powerful thing. They demonstrate to us that as lawyers, it is incumbent upon us to stop when other people don't want to stop. When other people want to drag somebody out in the street and beat them or shoot them, it's incumbent upon us to stop and encourage our friends and our neighbors and the people that we go to church with, the people that we drink coffee with in the morning, that we congregate with, to remember that just in the moment, when process seems so ridiculously unnecessary, that it preserves a system that the next day will benefit somebody who's innocent. And you think about that. I picked these two examples because one of them shows that the process works on the benefit of the people who are actually innocent. And that is a part of process that we can often very much relate to. The other end of the spectrum is that process works to preserve the values that we hold most dear. Excuse me. And if lawyers don't do that, nobody will. It is part of our professional obligation as citizens to make sure that we embody that in our own lives, and that in whatever way we can, we convey that to our fellow citizens. Now, here's another fellow, and this is the second part of it. Law, rule of law, government of laws as a resistance to power. That gentleman right there in that picture is one of the most heroic lawyers that I think I've ever encountered in my a study of lawyers going all the way back to the Middle Ages. There are other examples, but Joseph Hartinger is a truly heroic lawyer. He was a deputy prosecutor in the Munich prosecutor's office, and he was he'd been a career civil servant in the German system, the prosecutors are responsible for investigation and for the initial like probable cause stages of a criminal prosecution. It's a little, the civil law system is a little bit different, and we don't have to go into that right now. But Hartinger had a very sick wife and a 5-year-old daughter in 1933. So he had every reason to keep his head down, keep his job, keep his paycheck coming in, and keep his face out of the public opposition to the National Socialists. 32 is when the National Socialists obtained a majority in the German Reichstag, and then there was the Reichstag fire, then there was the imposition of martial law, and Dachau was the first concentration camp that opened. It was in the state of Bavaria, just south of the city of Munich is where Dachau is located. And it was the first of the Nazi concentration camps. At first, it was communist people and some Jewish people who were housed, but they mysteriously, and you can't see me, but I'm putting that in shadow quotes with 2 fingers on each hand, they mysteriously began to die with pistol and rifle shots to the back and back of their heads. The excuse always was by the people who ran Dachau that they had tried to escape, and so they were shot in the back. Hartinger risked his life and his career and the well-being of his wife and daughter because he put his livelihood at risk by doing this to bring these people from the SS to justice. He did an investigation, as I said, under the German system. The prosecutors are responsible for the initial stages beyond just the prosecution, but for the investigation, the compilation of what I would call the probable cause information, and then the initiation of the prosecution. And then if those steps are satisfied, then it goes to a court. And so Hartinger, at the risk of his own life, and ultimately he did lose his job. He was transferred to another office after this. Hartinger did put himself at risk in getting this information. He was willing because he could see that the arbitrary and xenophobic rule of the National Socialists was dangerous to every person in Germany, even when a majority of those people could not see that for themselves. And Hartinger very courageously stood up to the German authorities and gathered this information, put it in a file. Now, it was eventually intercepted by Himmler, who Hitler had appointed as the temporary military governor of the state of Bavaria. But Himmler locked it in a desk drawer, and later this information was uncovered by American intelligence officers and was used as part of the prosecution of the SS as a criminal organization in the Nuremberg. There were, in the International Military Tribunal, the big one that everybody remembers, where Robert Jackson made his famous speech, closing argument that you still hear quoted today. There were 23 initially, and then 22 because one of them got tried in absentia, and then 21 because one of the defendants committed suicide during the trial. There were also 7 organizational defendants, which were declared to be criminal organizations during the first Nuremberg trial. And one of them was the SS. And a piece of key evidence against the SS was the investigation that Hartinger had done at the Dachau concentration camp in 1933. And, so there I think is another piece of this. A government of laws is a government that produces lawyers who are courageous enough to stand up in the face of everybody else in society sometimes. And Hartinger did seem like he was in a really small minority in 1933, even then, and say, this is not right. Now look at it. You could look at it this way. Well, Hartinger failed because people kept on being shot. In fact, a lot more people got shot at Dachau before it was all over with. And then, my God, we had the camps that were nothing more than extermination mills that were established in Poland and in Eastern Europe. And so it can look an awful lot like Hartinger failed. And that's part of what I'm going to say about the balancing of this at the end. But he did not fail because he couldn't save the world. There were a lot of individual people that he couldn't save, but he did what he could in the face of overwhelming odds. He stood up to those people who were ruling in an arbitrary fashion, and he said as firmly as one individual could say, "No, I won't stand for this. I'll keep on doing my job. I'll do the best I can to oppose this." And though he was not immediately victorious, in the end, he did contribute to the ultimate victory over that kind of arbitrary rule. It's a pretty interesting, he's a pretty interesting fellow. And there's a book by Timothy Ryback, which I recommend to you highly, which is largely about Hartinger and his efforts at Dachau to bring those murderers to justice. So, first of all, a government of laws and not of, Madison would have said men, but we'll say persons, a government of law and not of persons is a situation in which people are willing to stand up for the rights of unpopular causes, like the British soldiers in Massachusetts in 1770, and like Rudolph Abel, the Soviet spy in 1950s America. It's also a government that produces people like Joseph Hartinger, where people are willing to stand up in the face of great personal risk and adversity and say to those in power, "You may not act in this arbitrary fashion," or "You may act in this arbitrary fashion now, but I will oppose you, and I will continue to oppose you with every fiber of my being," which is exactly what Hartinger did. So I say this, that was actually my summary slide. It's important, really, right? It sounds kind of hokey, and you probably think I've gone off the edge talking about this in an ethics update seminar. And to some extent, you may be right. We'll leave that decision for another day. But really, it's not, because it's an attitude. And if lawyers do not take the burden of internalizing this attitude and then externalize it by exemplifying it into the world. I'm not talking about being preachy to everybody we meet, but I'm talking about living our professional and personal lives in such a way that we demonstrate this respect for law to other people. And it will oftentimes won't matter what the substance of our otherwise personal opinions are, but rather that we demonstrate a respect for the process, a willingness to abide by the process, a willingness to say, okay, this person might be unpopular now, but they still deserve to have the same procedural protections that everybody else does. And then, as Hartinger did, when it comes to that, a willingness to stand and say no to the worst excesses of majority rule. And that, in another way, says this, wanted to say it also has to do with the dedication to the acquisition, exercise, and sharpening of our judgment as lawyers, and the turning of that outside. So this is a picture I took from the top of the Washington Monument. And that's the World War II memorial right there. That circular edifice is the World War II memorial, and that's the reflecting pool. And then, of course, at the other end of that is the Lincoln Memorial, right? So there you have that. I put this up here because I wanted to ask this question. So you just talked about John Adams. You just talked about James Donovan. You just talked about Joseph Hartinger, but you started out with ex parte merryman, which looks like an exercise of raw military power in the face of a reasoned judicial opinion. And it can look like that. But and that is a fine balance to walk. But I'm going to try to walk it for a minute in the service of reminding us about where one possibility for explicating comment 7 to the preamble to the rules of professional conduct. We think of this as a continuum, right? At one end of it is war. And there are two memorials to two great wars about liberty and freedom in the history of this country. At the one end of the reflecting pool, I guess that would be the northwest end of the reflecting pool there, is the Lincoln Memorial. At the other end of it is the World War II Memorial. Nothing in way speaks a better summary of a good war, right? The Civil War was about freedom in this country. World War II was about freedom worldwide. And that's one end of the spectrum. And it looks sometimes like the other end of that spectrum is what we do as lawyers, right? And we can think about it in that way. At one end, we've got a peaceful dispute resolution system has all these procedural safeguards built into it that we do as a business every day in our professional lives. At the other end of it is the raw violence of war. But really, these two things aren't opposed to each other. What we do is a replacement, but it's a replacement not in setting it in place of it. It's a replacement in the sense that both of these things are along a continuum. War at one end and the legal process at the other end. It's not separate from that. And more than anything, that may be what Merriman teaches us, right? Is that in our professional lives, we cannot ever escape the risk that we may have to end up at the violence end of the spectrum. But everything we do all day long is designed to be a safeguard against ending up there. And we understand that, and maybe my friend was right, even though it rubbed me the wrong way when he said it, I'll be honest and admit to you. Maybe my friend is right. I do think lawyers know better, but maybe I don't think that in an arrogant way, but in a way that creates a responsibility for us, because we live our lives in a way many other people do not along that continuum. And I don't know about you, but I mean, one time in 25 years, I had a witness get off the stand and come through the courtroom and ask me to go outside with them to continue the dispute by fisticuffs rather than by questioning and by cross-examination. It was an interesting situation. We live our lives on that continuum in a way that gives us a perspective that lots of other people don't have. And I think that's what Abraham Lincoln understood, right? We can't avoid the fact that the continuum exists. But what we can do is live according to these really brilliant examples that we've got of people like John Adams and James Donovan and Joseph Hartinger. And by the way, those are just three that I arbitrarily picked out for heuristic purposes. They're not, there's nothing magic about those three people. You could pick out three more examples. Lincoln realized that he had lived his life along this continuum too. And there was a time when the country was in danger, when the people in Maryland, led by John Merriman, were attempting to engage in violence to prevent supplies and troops from reaching the national capital. There was a time when it was justified along that continuum to move down to the closer to the end that's associated with violence rather than the end that is associated with the safeguards of legal process. But Lincoln also realized that if we permit ourselves too often and too quickly to go down that spectrum to that end, it will mean the degeneration of civil society and the placing of each one of us in danger. I say it like this, I can't think of a better way to sum this up. You know, we oftentimes, I guess you just saw that I lost a case in the Tennessee Supreme Court about 2 weeks ago about a question of statutory interpretation. And it's an interesting case because there's an interesting issue about legislative history in that case. I thought in the case that one of the legislators said something that was directly contrary to what the text of the statute said, and it's a fascinating instance of how to interpret a statute. And I came out on the short end of it that time, but it doesn't take away from the fact that it was a fascinating question, and it could have, I think, been answered either way, and it certainly is reasonable the way it got answered. And so it's interesting to see what we do, but you look at it like this. This is we oftentimes get very wedded to the text, very wedded to the text of the Constitution, very wedded to the text of statutes. And then, even though we have to respect the text because it has to be the starting point every time, we can move it into something that it's ill suited to do and reach a result that sometimes can be a problem. And I can't think of any better way to sum this up than this quote from Terminiello by Justice Jackson's dissenting opinion. This court has gone forward toward accepting the doctrine that civil liberty means the removal of all restraints from these crowds. The issue in Terminiello was whether or not somebody could say things that would incite a crowd in Chicago and then have violence happen after that. The choice is not between order and liberty. It is between liberty with order and anarchy without either. There is danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the constitutional Bill of Rights into a suicide pact. And I think that is the thing that Lincoln recognized in Merriman, right? What he recognized was that the court had made a decision in the form of Justice Tawney, the circuit judge for the District of Maryland, had made a decision that it explicated. You read the decision, the opinion that Justice Tawney wrote, you won't see anything overtly unreasonable about it, and it looks like it respects the text of the Constitution. And there were a number of people who thought that because the habeas corpus suspension was in Article 1, it only could be suspended by Congress and not by the president. Lincoln realized that adherence to the text at that dangerous moment would be worse than safeguarding the republic by engaging in the action that he did. And that brings us to this point, right? It's a choice that we have to make in those cases. But as lawyers, it is our responsibility, as many times as it possibly can be done, to make the choice, to live out the choice in the way we practice, in the way we deal with people, and in the way we explain what we're doing to people, to make that choice as many times as possible toward the end of the spectrum that respects the process, toward the end of the spectrum that preserves people's safety and peace. And only when it's unavoidable, like perhaps it was in Merriman, if you'll have to make your own judgment about that. I can't make it for you. But like it was in Merriman, perhaps, that it goes down to that other end of the scale. We can't ever get away from that, right? We couldn't have walked away from World War II and said, well, some legal process will take care of this, any more than Lincoln could have walked away from the Civil War and said a legal process will take care of this. There's a time when people are more important than the text of whatever thing we're defending. But that judgment is something that we have to practice, live out, and then learn to explicate to other people so that we stay on the end where it's safe as much as possible. And that is what I think the point and purpose of that comment 7 to the preamble is. And next year, I'll talk about something much more mundane. I thank you for listening to me and having me on this afternoon, and I'll hand it back to Andy.
Great, thank you so much. We will go ahead and get started with our next presenter, Laura Chastain. You should have now be made a panelist, Laura, so you should be able to unmute yourself and start sharing your screen, and you're good to go.
Can you hear me?
Yes, we can, and we can see your screen. And if anybody has any questions during the presentation, make sure to put them in the chat box, and I will ask Laura as she goes.
All right, that sounds great. It's certainly a pleasure to speak to this group always. I think you know what I do as ethics counsel because I've talked to a lot of you in the past. So we're going to talk today about the current developments, new rules, new cases, those sorts of things from the Board of Professional Responsibility. On your screen, you can see the mission statement for the board. And really the board has 3 goals. One is to protect the public from unethical lawyers by assisting the court in administering the disciplinary process. And then the second goal is assisting the public by providing information about the judicial system and about the disciplinary system. And then the third goal is to assist lawyers by interpreting and applying the court's disciplinary rules. So with those 3 goals in mind, let's look at first at administering the disciplinary process. This is how the board assists the court, the Supreme Court, that is the ultimate entity that administers the disciplinary process, but the board does the work for the court in this manner. In front of you, you're going to see the part of the annual discipline report, and what it shows here is our fiscal year runs from July to July. So we're going to see the years 2018-19 and 2019-2020. And as you can see on there, there were 2015 total complaints in the year 2018-19. And then in the year 2019-20, which went through July, there were 1,668 complaints. So there were really 347 complaints that were less than the year before. And we don't know the reason for that, but I think that it may have something to do with the fact of the pandemic. Everybody was busy trying to figure out how to change their practice to virtual and remote. And so maybe they didn't have so much time and then the complainants were busy trying to figure out how to deal with the lawyers. So they may not have had the time to file the complaints, or maybe just lawyers are doing a better job. The next slide shows the nature of the complaints that we received last year. And as always, neglect and failure to communicate is the largest area. 45% of the complaints last year were on neglect and failure to communicate. And then notice up there, conflict of interest is only 5% of the complaints. Well, when I answer the ethics inquiries, it's really interesting that the largest number of questions that I get are about conflict of interest. Last year, about 30% of the questions I got were about conflict of interest. And I think that's because that's such a complicated area, because you have current client conflicts, you can have conflicts with former clients, you can have conflicts with regard to prospective clients, and then your personal interests can sometimes end up being a conflict. And not surprisingly, the inquiries that I get about this neglect and failure to communicate was less than 1/4%. So nobody's really interested in finding out about how to handle communication and neglect. And it shows in the nature of the complaints here. This picture here shows the disposition of complaints. And these are complaints other than formal charges. This talks about the disposition of complaints that haven't resulted in formal charges. And you will note that after investigation, 42% of those complaints were dismissed. 42% were also administratively dismissed. And what that means is when the chief counsel gets a complaint and reads it, if everything in that complaint is true, but it wouldn't be a violation of the rules, that's administratively dismissed. And you may never know that you had that because, no letters are sent. It's just put in the trash, basically, because there was no violation of any rule, even if everything that the complainant alleges is true. Then you see 3% were handled by diversion. And diversion is not a discipline. Sometimes it's offered when there's been minor infractions of the rules and people are diverted to a workshop or to some CLE on a specific subject. I know the board has had a trust account workshop for people that have had problems with their trust account that were minor record keeping problems. So that's what diversion is. And by the way, if you're ever applying for a judgeship or anything else, and they ask if you ever had discipline, if you've had diversion, you don't have to say anything because that is not a discipline. Then private informal admonitions. This is known as a PIA. 2% of these complaints ended up in that. And that's the lowest form of discipline. And it's just a letter saying, you really have done something wrong here and you need to correct it, but it hasn't caused any damage and it was a minor thing. Then private reprimand, that's a stronger discipline, but it's also a private discipline. And 2% of the complaints ended up there. Then informal public censure. An informal public censure is issued by disciplinary counsel with the concurrence of a hearing committee member. Anytime any discipline is proposed by disciplinary counsel, it's sent to a hearing committee member for approval. And if the hearing committee member approves it, then it's issued to the attorney. So an informal public censure is where the attorney accepted the censure, and that's the end of it. However, if the attorney wants to have a hearing and then goes to a hearing on a censure, and it becomes a public censure from a hearing panel, then the attorney has to pay the costs of that. And again, they might have had a private reprimand and decided that they wanted to have a trial. Well, the lowest form of public discipline is a public censure. So if the hearing panel finds that the lawyer's done something wrong, they can't dismiss it. They would have to give a public censure. So that would be a formal public censure after formal proceedings. Then transfer to disability and disability and active status. This is when an attorney's mental or physical condition keeps them from being able to defend themselves in a disciplinary matter. And also, even if they're not in a disciplinary matter, a lawyer can take disability inactive, but this is talking about the disposition of complaints. So 1% of those that had complaints transferred to disability inactive. Then placed on retired status, 3%. And you may wonder, well, why would we retire a file at the board? Many times civil proceedings and criminal proceedings are going on with the subject matter being what has been filed as a disciplinary complaint. So in those instances, the board retires those complaints until the civil matter or the criminal matter is complete. And a lot of times there are appeals, and so it takes a long time to find out the final judgment. But normally the board will wait if there is a companion case to see how the courts rule on that. And then finally, 1% are handled by other. And that means that either the respondent died, the complaint was withdrawn, or there was a duplicate file. Now this talks about the formal charges. You know, we just talked about complaints, how they were disposed of that were not formal charges. Well, this is formal charges. And you can see that in 2018-19, there were 242 of those. And then in 2019-2020, there were 199, or 43 less formal charges. This slide shows the resolution of some formal disciplinary proceedings for those years. And the blue boxes are the 2018-2019 resolution of formal disciplinary proceedings, and the brown boxes are 2019-2020. So you can see that in 2019-2020, dismissals were up, public censures were up, suspensions were down, disbarments were down, disability inactive was definitely down, temporary suspensions were down. However, retired files that might have had companion cases were up, reinstatements were up, and then other things such as the respondent being deceased are down. So that's how the formal disciplinary proceedings were resolved. This next is an order of the Supreme Court. And this was an interesting thing that happened this year. The court on its own decided that it was going to amend some rules. And one of the rules that was amended was Rule 9, which is the disciplinary enforcement rule. And 3 sections of that rule were amended, Section 8, 12, and 30. Section 8 is about jurisdiction. And what the court did was they added jurisdiction for lawyers who were disbarred or suspended, but continued to practice law. And they, in that amendment, also directed disciplinary counsel to refer those cases to appropriate authorities, either criminal or civil. So they added the jurisdiction. Now, Section 12 is the discipline section, and under suspensions, the court changed the maximum discipline to be 10 years. In the past, the maximum discipline a lawyer could get, a suspension that a lawyer could get, was 5 years. Now the maximum suspension time is 10 years, and the minimum suspension time remains at 30 days. Then the most striking change was in Rule 30, or Section 30 of Rule 9, which is the reinstatement rule. After July 1, 2020, any lawyer that's disbarred can never be reinstated. So Tennessee has joined with approximately 8 other states in having permanent disbarment. So anybody that's disbarred after July 1st, 2020, it's permanent. They can never be reinstated. This is another rule change. This was section 26, and this was about privilege tax. And what the court did is they said that the Board of Professional Responsibility needed to give notice to attorneys that had not paid their privilege tax. So the Department of Revenue on a monthly basis sends a list of attorneys who've not paid their privilege tax. And then disciplinary counsel sends a notice to those lawyers. And if they don't pay within 30 days, then the court says they will be suspended and they will be charged a $100 notice fee to the board. And they can't practice law until they get an order from the court allowing them to resume practice. In the past, when a lawyer didn't pay their privilege tax, they could just pay the tax and prove it to the board, and then everything was good. They were back active. Now it's requiring a court order for those people that have been administratively suspended for failure to pay either their dues or their privilege tax. There has to be an order of the court reinstating those persons before they can continue to practice. And here's one more order. And this is a very important order for everybody to know about because this makes a new trust account rule. Lawyers for a long time have been finding money in their trust account that they can't identify. They don't know who owns that money. And so this is a little different than having money that you know who owns it, you know who should get it, but you can't find the person to pay them. That's a different thing. But if you don't know who the money belongs to, then there's this new rule that is Rule 1.15F. And it says that a lawyer who learns of unidentified funds in an IOLTA account must make periodic efforts to identify and return the funds to the rightful owner. If after 12 months of the discovery of the unidentified funds, the lawyer determines that ascertaining the ownership or securing the return of the funds will not succeed, the lawyer must remit the funds to the Tennessee Lawyers Fund for client protection. No charge of ethical impropriety or other breach of professional conduct shall attend to a lawyer's exercise of reasonable judgment under this paragraph F. So that's a totally new rule that's been added to the rules of professional conduct. On the board's website and on the website for the Tennessee Lawyers Fund for Client Protection, you can find this form to fill out if you're going to remit funds. And you can see there that you can put the amount of funds, the attorney or the law firm that's remitting the funds, the date, and then you have to certify that for at least 12 months you have been trying to find who owns these funds and can't find them. So at that point, you put your name and you sign that and date it. And there's a footnote there that says if later you find out who owns the funds, then you can make a claim on the Tennessee Lawyers Fund for Client Protection and the money can be given back to you. I was surprised to know several people have told me that they didn't know what the Tennessee Lawyers Fund for Client Protection is. It is a fund that was established to reimburse clients whose lawyers stole their money. And recently the court gave that job to the Board of Professional Responsibility. It used to be run by the CLE Commission, but because the board has disciplinary counsel that are investigating these cases, I think the court thought it was a better match to have the board be in charge of that. Now, the Tennessee Lawyers Fund has their own board that makes decisions, but the disciplinary counsel at the Board of Professional Responsibility does the work for this. And the fund is set up where $10 of your dues every year are given to the fund for the purpose of reimbursing clients whose lawyers have taken money. Now we're going to talk about some recent disciplinary cases. And the first one is a very interesting and complicated case. It's a 29-page opinion by the Supreme Court. And this is a case of James Dunlap. Mr. Dunlap was not a Tennessee lawyer. He was a Georgia lawyer, but he got admitted pro hoc vice. And he represented Tri-Cities Holdings. And this LLC was trying to operate an outpatient methadone clinic in Johnson City, Tennessee. So he had to apply, for a certificate of need. And while he was doing that, he filed a federal lawsuit against Johnson City, asking the court to declare that their zoning ordinance concerning methadone clinics violated the Rehabilitation Act and the ADA. Well, the federal court in East Tennessee dismissed the case and said it was not ripe while the certificate of need was pending. And so after that, after the dismissal of the case, the Health and Human Services organization denied the application for certificate of need. So Mr. Dunlap files what you would do, filed an administrative appeal. But he also, a couple of days later, filed another federal lawsuit. And because his first one had been dismissed, he filed this one in Middle Tennessee. And the judge figured out what was going on and said, this is obvious judge shopping, and transferred the case to East Tennessee. So again, he has this federal court lawsuit pending, and he tells the administrative law judge that she needs to put a stay in place because of the ongoing federal case. And so this went on, and there were several telephone conferences. And in July of 2013, September, November, and then January of 2014, he continues to tell the judge that there's been no action in the federal lawsuit. He never told the judge about the first federal lawsuit that was dismissed. So what happens next is the Health and Human Services people decide that they want to have a hearing because this is drug on and on and on. So in March, they file a motion to set, and they attached a copy of the dismissed case. So the administrative law judge got very upset and said that she was not going to issue a stay, was going to set it for a hearing. And so Mr. Dunlap says that he thought this administrative appeal just amounted to a scheme or artifice to violate the ADA, and that he thought the judge, the administrative law judge Summers, was a fixer, and that she was risking aiding and abetting this crime that he thought was happening. And so he said that he was going to sue her if she did not put a hold on the administrative appeal. Well, at this point, Judge Summers revokes Mr. Dunlap's admission to practice pro hoc vice, and then he files a motion to recuse her. Well, she denies the motion to recuse, and this whole thing ended up with Judge Summers filing a complaint with the Board of Professional Responsibility. And during the hearing, Judge Summers testified that she was incredulous that Mr. Dunlap had misinformed her about what was happening in the federal case, resulting in a stay of the administrative appeal for 8 to 9 months. So the hearing panel found that Mr. Dunlap had really violated several rules. One was candor to the tribunal. One was seeking to influence the judge by means other than provided by law, and conduct that was prejudicial to the administration of justice. And they ordered a 1-year suspension. Well, Mr. Dunlap then filed an appeal to the next level, and the trial court there found the same and thought the suspension was fair and proportionate. So Mr. Dunlap appeals then to the Tennessee Supreme Court, who sets out all of the reasons they found that the hearing panel's decision was correct. They thought the discipline was proportionate, and they taxed the cost of the appeal to Mr. Dunlap. So Mr. Dunlap is suspended in Tennessee for 1 year. And as you know, there's reciprocal discipline. So I imagine by now he is suspended in Georgia as well. The next case we have is that of George Thompson, who's a Middle Tennessee lawyer. And Mr. Thompson had a case in which it was a personal injury case, and he had filed a non-suit and then failed to refile the case in a timely manner, and it was barred by the statute of limitations. So what he did was he paid her a sum of money to settle her claim against him and failed to advise the client in writing that the client should seek independent professional judgment. Well, what he did was give her a memorandum that basically said he was paying her $500 and would make every attempt to make her whole. And then she decides she's going to file a complaint. So she did file a complaint with the Board of Professional Responsibility. And it went to a hearing panel who suspended Mr. Thompson for 1 year, with everything except 30 days being suspended, and having him on probation for that 1 year with a practice monitor. Well, he thought this was terrible, that this would happen. And he filed an appeal, and he said this is the whole issue in his appeal was that the discipline was too much. And so the court goes through, when it got to the Supreme Court, the court went through his prior disciplinary record, and he had been sanctioned by the board on 7 different occasions before that. In 1994, he received a private informal admonition for allowing the statute of limitations to expire in a personal injury matter. Sound familiar? In 1995, he received a private informal admonition for failing to act with reasonable diligence in 2 cases. Year 2000, he received a private reprimand for failing to act with reasonable diligence in a bankruptcy case. Year 2000, he received a public censure for allowing the statute of limitations to expire in a personal injury matter. 2003, he was suspended for 1 year by the Tennessee Supreme Court, with the entire suspension to be held in abeyance during a period of probation with conditions for failing to timely refile a personal injury matter after a voluntary dismissal. Absolutely the same kind of conduct in this case. In 2006, he received a private informal admonition as a result of a trust account overdraft. 2011, he received a public censure when he failed to adequately communicate with one client and failed to advise a potential client he was declining to represent the client prior to the expiration of the statute of limitations. So really, so much neglect was here, and the court found that this was really an aggravating circumstance, and found that the suspension with only 30 days active and a practice monitor was really generous in looking at the prior discipline of Mr. Thompson. So the court gave him exactly what the hearing panel did, a year suspension, and he's on probation for the year, 30 days active suspension with a practice monitor. This is a list of our board members. Lots of people want to know about who our board members are. And we have 9 lawyers on the board and 3 non-lawyers. Many of you probably know Floyd Flippin, who's the chair of the board. He's from West Tennessee. Joe Looney's the vice chair. Sheriff Floyd Bonner, again from West Tennessee, is a lay member. Stacy Edmondson, Ruth Ellis, Jennifer Hagerman, John Kitch. Senator John Lundberg is from East Tennessee, and he is a lay member. Jimmy Miller, Juanita Patton. Juanita Patton is a lay member. She's a banker in Nashville. Then we have Jody Pickens, who's District Attorney General in West Tennessee, and Bridget Wilhite. So those are the current board members. This is a list. I know it's so tiny you can't read the names, but I just wanted to show you how many hearing committee members we have. There's 178 of those hearing committee members, and they're appointed by the Supreme Court. And these hearing panels of 3 hear disciplinary cases, and then they make recommendations to the Supreme Court for discipline of lawyers. And I've had a lot of people ask me, how do you get to be a hearing committee member? Do they get paid? And the answer is they don't get paid. They're voluntary, but they are appointed by the Supreme Court. And so if you have an interest in being a hearing committee member, you might talk to a board member in your area and tell them that, because they make the recommendations for hearing committee members. Or you could send a letter to the Chief Disciplinary Counsel, Sandy Garrett, and tell her of your interest, and she would pass it on to the appropriate board member. The next slide here is the Disciplinary Council, and you can see Sandy Garrett is the Chief Disciplinary Counsel. Stephen Christopher is the Deputy Chief Disciplinary Counsel of Investigations, and Russ Willis is the Deputy Chief Counsel in Litigation. Then you see the litigation attorneys listed there, the investigation attorneys, and Joe Bird is a new litigation attorney, as well as Doug Bergeron, who is a new investigator. And then Beverly Sharp is the director of the Consumer Assistance Program. And there you see my name at the bottom as Ethics Counsel. So now we're to the second goal of the board's mission statement, to assist the public. And again, this is a page from the discipline report. And these, what the Consumer Assistance Program does is help the public. It's called CAP, Consumer Assistance Program. And they get information or complaints from citizens about lawyers. Many times they're asking for assistance with their lawyer. And here's what happens. A lot of times matters between a lawyer and a client are mediated. 34.6% of the actions taken were mediations. And sometimes it's mediations between lawyers. For instance, lawyers are that are sharing a fee cannot decide how it's to be shared. They're fighting over that. Another thing is the new lawyer can't get the client file from the old lawyer. Well, they can ask for assistance from the Consumer Assistance Program, and someone will contact the lawyer that has the file and say, you know, that's the client's file, you need to turn it over. And so these things are done without any discipline. This is not a discipline program. So many times when Ms. Garrett gets a complaint that really is not anything that would be a violation, it's either administratively dismissed, but if it's clear that the complainant doesn't understand the legal process at all, it's sent over to the CAP program to explain to these people the disciplinary program and the judicial system. A lot of times people just don't understand how that works. So you can see that 45.6% of people were advised by the CAP program. And then referrals to other agencies. Many times complainants file a complaint, it's about a judge, not about a lawyer. And so they are referred like to the Board of Judicial Conduct. And then information about the judicial system, about the disciplinary system. And I will tell you that 76% of the matters that go to the Consumer Assistance Program are filed by criminal defendants. And 23% are from civil matters. So last year, they received 2,278 matters, problems people were having. And those were the actions that were taken and the percentages of that number. This is the complaint form that's on the board's website, and you can see at the top, it says, check one of the following. I'm submitting this form as a formal complaint. I'm submitting this form as an informal request for assistance. So if you're a lawyer and you need some assistance with a matter, you can check that. But if you're a lawyer and you're filing a complaint, you wouldn't use this form. This form is for the public. You would just write a letter to the Chief Disciplinary Counsel, setting out the facts of your complaint, and then attach any documentation that would support the complaint. All of you probably know that you have to have your bank account in an approved bank. And what that means is the banks have agreed to notify the Board of Professional Responsibility in the event of an overdraft in the trust account. There's a list of these approved banks on the board's website. So you have to have your trust account in an approved bank. And so when there's an overdraft in your trust account, then a notification is sent to the board. And last year there were 103 notifications of overdrafts in attorney trust account. After there was an explanation, 31 of those were referred to an investigation. 2 were referred to litigation, where it was clear that misappropriation had taken place. And then 72 were resolved without investigation. And that's where there was just some accidental problem with the trust account that created the overdraft. You wouldn't be surprised probably to know that the bank makes errors. And so many times it's a bank error, or the attorney used the wrong check or something to that effect. So as long as it was taken care of and there was no misappropriation of funds, those are resolved without investigation. Then finally, we get to the third goal. And this is my favorite goal because I get to work in this area, and that's the area of assisting lawyers. We have educational information that goes out from our office, and that's really a fun thing for me to do because for years when I went to the work for the board in 1990, and for 17 years I prosecuted attorneys. And this is so great because I can now help attorneys before they get into the area of being prosecuted. So it is much more fun for me to help people out before something happens. And again, I can only help lawyers prospectively. If they've already done something wrong, I can't do anything about that. But anyway, we do ethics opinions, and that I think is something that the lawyer community appreciates because we had 2,533 questions last year that were responded to. We didn't have any formal opinions last year, and on our next slide, I'll show you probably why that is. But we did 53 CLEs. So board staff attended and presented at 53 CLEs, just like this one. And then we have the board notes newsletter, and that's put out by the chief counsel. And it has all sorts of information in it. It shows all the discipline of attorneys for the year. I think it comes out yearly or possibly quarterly, but whenever it comes out, it shows the discipline of attorneys. It shows information about rule changes. It's a very helpful thing, and it goes to everyone's email. So don't delete it, take a look at it. It might be helpful. Then finally, we have workshops. I'm sure most of you know about the annual workshop that we have at the Nashville School of Law. And the last one we had over 400 people that attended. It's a very good workshop. You can get most of your CLE credit hours for the year, and it's at a very low cost. And so people like to sign up for that. But this year, because of COVID, we didn't have it. And hopefully in October or November of 2021, we'll have it again. We have had 2 trust account workshops this past year. And so that's something that lawyers can do. if you're having problems with your trust account, we do hold those workshops. And also, if you get in trouble, say, let me go to a workshop. I didn't know about my trust account records. And I think a lot of those are the diversion to trust account where you've had a record problem. All right, so I'm going to talk about the formal opinions. There's a new board policy about formal ethics opinions. You all may have remembered the opinion that went out about prosecutors having to give defense counsel exculpatory information. Well, eventually that got set aside by the Supreme Court. And as a result, the board initiated a new policy that ethics opinions would be put out for public comment prior to them being issued. So here is the new policy. Requests for formal ethics opinions should be in writing addressed to the board in accordance with Tennessee Supreme Court Rule 9, Section 5.4. And that is a specific rule that tells you what you need to put in your request. And part of it is a memorandum or brief on why you think it should be, what the rules are. And you also have to make a certification under that rule that this is not pending in any court or disciplinary hearing. So if that's the case, you've made the request, then the board may vote to issue a formal ethics opinion pursuant to the written request. And the ethics committee, with assistance of me, prepares a draft formal ethics opinion. Then that draft shall be considered by the full board. And if the draft formal opinion is approved by the board, then disciplinary counsel shall publicize the draft formal ethics opinion for comments from judges, lawyers, bar associations, and members of the public for 30 days on the board's website and through TBA Today. Then those filed comments are posted on the board's website. After the expiration of the comment period, then the board will consider the filed comments and vote to approve, revise, or disapprove the formal ethics opinion. So all of that takes a long time. And if you're asking for a formal opinion, you need to know ahead of time that it's probably going, best case scenario, take about 6 months because the board only meets quarterly. Also, if it's a narrow question, the board is likely not to issue a formal opinion unless it's going to affect a substantial number of the bar. In the past, as I said, the past year, there were 2,533 informal ethics inquiries. And there's some times when I can't issue an ethics opinion. One is if you've got a matter pending in court, or it's a matter of a disciplinary complaint. If you've got a complaint filed against you on a subject, you can't get an opinion. If you have a matter in court saying you're trying to disqualify someone for a conflict, or they're trying to disqualify you, if it's pending before a court, we can't give an answer because that takes away the discretion of the judge. We don't give opinions on the conduct of other lawyers, only on your conduct. And then legal questions. The board can't be giving legal advice, so I'm prohibited from answering legal questions. And then finally, I can't give an answer about your past conduct. So if you're thinking about doing something, call first, or right now we're doing it online by email or using the board's website, informal inquiry forms. Do that first before you take action, because if you call me and say, I did this, have I done anything wrong? I really can't give you an answer. I can tell you what rules are involved, but I'm prohibited from giving answers on past conduct because it may be the subject of a disciplinary complaint. I can give you answers on what you should do prospectively. And then if you follow that, it is very unlikely that you would ever be prosecuted. I do not know of any situation where a lawyer asked for a guidance, followed the guidance, and then was prosecuted because the guidance was wrong. we're just not going to do that because it's showing your good faith that you followed what you were told that you should do. This slide shows all of the subject areas of the inquiries that we get. And again, I will call to your attention that big conflict of interest area. 29.13% of the inquiries are about the conflict of interest. And then call to your attention neglect up there, 0.24%. So basically, there were only 7 questions about neglect. This is a very good formal ethics opinion. It's from the Pennsylvania Bar, and it came out in April of 2020, right after the pandemic hit. And Governor Tom Wolf ordered all non-essential businesses, including law firms, to close their offices during COVID-19 pandemic, and ordered all persons residing in the state to stay home and leave only under limited circumstances. Many attorneys and their staffs were forced to work from home for the first time. And so they were calling on the bar to help them out. And most of the questions that the bar got were about how to work remotely and about technology. So the opinion says that an attorney practicing in a virtual office at which attorneys and clients do not generally meet face-to-face has to take appropriate safeguards to confirm the identity of clients when you're talking to them over the phone. You have to address circumstances in which the clients may have diminished capacity because of the pandemic. You have to take care to maintain client confidentiality. And at a minimum, remotely, attorneys and their staff have an obligation to take reasonable precautions to ensure that all communications, whether it be telephone calls, text messages, emails, or video conferencing, are conducted in a manner that minimizes the risk of inadvertent disclosure of confidential information. And the remote workspaces have to be designed to prevent disclosure of confidential information. And I will tell you that that is why I am having people to email me or use the board website ethics inquiry forms so I can answer online, because to have confidentiality, I can't be talking to people about their ethics dilemmas where other people can hear that. So if it's absolutely necessary to have a phone call, what I've been doing is scheduling it where I can be in a totally private space to take that call. The opinion says that an attorney working from home or another remote location is under the same obligation to maintain confidentiality as an attorney is when working within a traditional physical office. And then something that I had not thought about, we're talking about this communication needs to be private. How many of you have Alexa or Google Voice? Both of these programs may listen to conversations and record them, and I would never have thought of that. So that's something that this opinion brought out. And then the opinion talks about many ways to enhance your security, your online security. You can avoid public internet or free Wi-Fi, so don't go to Starbucks and try to do your remote work. Use virtual private networks, VPNs, use multi-factor authentication, use strong passwords, and be sure that your video conferences are secure. Do not make your meetings public. And these are sections, these suggestions were put out by the FBI after there were a bunch of hacking into Zoom. So the FBI put out this list: don't make your meetings public, require a meeting password, do not share a link on social media, provide meeting links directly to specific people, manage screen sharing options with the host only doing that, Ensure that users are using the updated version of the application. Back up any data stored remotely, and be sure that security is looked at in your remote places with regard to your computers. Don't use your home computer for work. If anyone else has a password to the computer, you should not be using it for work, because that definitely is a problem with other people being able to view client information. The American Bar Association has put out an ethics opinion here that I think is something that you should probably get. It's about prospective clients. And this is something that I hear about a lot of times and ask questions about. What about conflicts with this prospective client? And what about the confidentiality? Well, in those situations, you're not disqualified just because you talk to somebody, but you are disqualified if you get information from that prospective client that is, quote, significantly harmful to their case. And this opinion goes through things that would be considered significantly harmful. You know, 1.9, if you have a former client and it's the same or substantially related matter, or you have information from that matter, you can't represent the other side. But if you have a prospective client and you don't get information that's significantly harmful, you can take the other side. Or if you get significantly harmful information, you can use screening, and another lawyer in your office could represent the other side. So this is a good opinion to have. This is again a screenshot from our webpage, and you would click on legal professionals here to get the board informal ethics inquiry form. And you notice it says the board is operating remotely. For informal ethics inquiries, please enter your inquiry online using the informal inquiry form. Ethics Council will be receiving informal ethics inquiries online only. And that pretty much has been the case. You click on that and here's what comes up. And if you see down on the left-hand side under search, if you click on that informal ethics inquiry, a form will come up. You can put your facts in it and your questions, and then I will respond in writing, and you will have an informal ethics opinion for your file. I've been asked a lot about where can I find the rules of professional conduct and formal ethics opinions. Again, if you click on that legal professionals box on the website, this will come up, and look down under rules. There you will see that all the board policies and rules are there. The rules of professional conduct, which are Supreme Court Rule 8, the rules of disciplinary enforcement, Rule 9, interest on lawyer's trust account, Rule 43, and then regulation of lawyer intermediaries, which has to do with advertising. There are a lot of resources there, and one other one that I will point out down on the right-hand side is resources for when an attorney is unable to practice law. If you have an attorney that's deceased, I've gotten a lot of questions about, you know, this sole practitioner that was deceased, and now we don't know what to do. Well, this has checklists and it has forms for asking for a receiver to be appointed for those files. So that's a good resource to have. And then the last thing I want to talk to you about is proactive based regulation, proactive management based regulation. What this really is a voluntary self-assessment of your law firm. And the great thing about it is you get free ethics, 3 hours of ethics or dual credit for taking this. And how this started was in 2009, there was an Australian study of lawyers that undertook this self-assessment. And they found that 2/3 of the complaints that they'd been getting didn't happen anymore, because they found that this brought people's focus to what is going wrong in your law firm. So in 2019, the ABA said, this is so great. We've seen this study. We want the states to adopt something like this. So in response to that, Colorado, Illinois, New Mexico, Iowa, and now Tennessee has implemented this proactive based regulation. And it talks about, you'll go through it, and it talks about practice areas, about developing competent practices. It talks about effectiveness, communicating in an effective, timely, professional manner, ensuring that confidentiality requirements are met, avoiding conflicts of interest, retaining and managing secure files, managing the law firm, charging appropriate fees, ensuring the use of reliable trust account practices, access to justice and client development, and promoting wellness. It goes through all of those on this self-assessment. And then at the end, you will get a certificate, if you've completed it, that you can send to CLE, and you will get credit for 3 dual credit hours. So this is something that I think you might want to do if you're behind in your CLE, for sure. And if not, it will definitely help you in your law practice. Andy, have we had any questions?
We have not had any questions. We've got about 3 more minutes left. If anybody has any questions, make sure to ask them. But if not, you can keep on going.
All right. Well, that I'll show you this next slide here. This is an example of the question that would be asked on the self-assessment. In deciding whether to undertake representation, do you assess whether the new clients have needs or preferences that require additional time? And then your selection of answers is never, seldom, sometimes, very often, always, or not applicable. So if you answer that question, that's part of the self-assessment. But over on the right-hand side, you can see sample resources with regard to that question. And the ABA Standing Committee has an ethics opinion that talks about ethical obligations of lawyers who represent indigent criminal clients when excessive caseloads interfere with competent and diligent representation. So if you decide that these clients are going to need additional time, you might want to look at what the ethical obligations are when you have too many cases. Something to think about. Also, there's a case in Ray Nunnery suspending a lawyer for 2 months because he did not conduct a meaningful inquiry into the veracity of documents presented by his clients, mainly because he didn't have the time. And so this is an important question to ask when taking on a case. And then down at the bottom, you can see that there's a article that you can read, that you click. And when you click on these links, it takes you directly to those articles that might be helpful to you in that area. Available on the board's website. This is the thing that I just told you about, the PMBR. People have called me and said they couldn't find it on the board's website, and you just need to click on legal professionals, and then you can, it will come up at some point there, and you can click on it. If you don't, give me a call and or an email, and I will try to help you with that. You can see my contact information there. I've highlighted my email address because that is the best way and the quickest way to get an answer to your question, unless you put it on the board's informal inquiry form. I have given you some other contact information, and I would like for you to look down at the Tennessee Board of Judicial Conduct. I get a lot of questions about judges, and this is where you would call to get the answers about judges' conduct. Marshall Davidson is the disciplinary counsel there, and he answers that phone number. I think it's his home phone number. So, anyway, that's the end of my program, and I've enjoyed talking to you. I wish I could see you, but I'm sure there are too many to see. And thank you again for the opportunity.
Great. Thank you so much, Laura. We will go ahead and take our 15-minute break. So we will be back up at 2:45. Thank you so much.
Thank you.
Andy, can you hear me? Andy.
Yes, sorry. My mute wasn't popping up. My unmute
No,
wasn't.
I understand. And if I need to get on a cell call, I will. I sent you my handout.
Yes, I got it.
Okay, so the question is, I mean, that's what I do each year. It's not, obviously it is not PowerPoint.
Correct.
I am working off a tablet
Okay.
because it's a long story. But so the question is we can tell them they can hit the link and they can follow along, and then you can show my smiling face. Or if you've uploaded it yet, I don't know how we would do it with me saying page 3, page 4, page 5, the case on page 9, with you
Right.
moving it. Does that make sense?
Yeah, I think the best way, we had one like this last week at our seminar, is to do, everybody should have access to it. And I will put the link in the chat function just to make sure. And people can pull it up and they can go through it. And then you can just put your video on and we can go from there.
All right, that sounds good.
All right.
Okay, are you hearing me okay?
Yeah, your sound's coming in perfectly fine.
Okay, good. Then why don't you, when we come back on, would you just be my check? In other words, Bruce, move to the left, or
Yeah.
just so we don't have, I love the guy pouring coffee and with the boxes.
Yeah, absolutely. I will, whenever we come back on, we'll get you up and going, and we'll get it figured out.
Okay, and if it's with a tablet, do you think it's better to do it with it sitting lengthwise or up and down?
I think sideways would be best.
Okay, very good. I appreciate it. Okay.
Absolutely.
Okay. All right. I'm going to step away, and what I can do, I always find some fly specks, but certainly I can. Okay. Deborah Owen saying our conversation is audible. I can send if you want me to, at the end, you can let me know if you want me to send a revised and slightly cleaned up version.
Sounds good. I'm putting the link in the Dropbox for everyone.
Okay, very good. Thank you very much. Do you know whether Lewis or Laura are still going to be with us, or?
They are not currently on, so I don't think so.
Okay. All right.
Lewis had
Thanks.
I think Lewis had a hearing this afternoon.
Okay. Okay. And I apologize for not getting on 10 minutes before. Okay. And I'll make sure that we go till at least 3:45 to make sure that we get the full hour of credit.
Perfect. Sounds good.
Thank you.
All right, everybody, we will go ahead and get back started with our final speaker of today. Bruce, you can go ahead and unmute yourself, and we will get started.
I should be unmuted.
Yes, you're unmuted, so you can go ahead and start your video. As a reminder to everybody, I just posted the link to all the materials in the chat box. If you want to comment on anything on your computer, on the materials, you'll need to download them. You won't be able to in the Dropbox. So download the materials if you want to make any notes on them. And then additionally, your form to get your CLE credit is included in that. So you can fill that out and email it to me by December 28th. But Bruce, you can go ahead and go.
Andy, the box I'm getting says that you have disabled me from video.
Oh, give me just a second. Well, this did not happen last time. Let me just 1 second. Let me get that going.
Do you want me to hit start video again?
Yeah, try it. You should have the ability.
Nope, you cannot start your video because the host has disabled it.
Well, you might not have video then. It's not showing that you're disabled on my end, so I'm not sure
Do I need to hit participants?
No, you should.
No. Okay. All right, I'll just start. I'll start going. Okay. Good afternoon, everyone. It's great to be with you again. This is the Ethics Update 2020, the year in review. It is a review done each year on how lawyers get in trouble with their clients, with courts, with the Board of Professional Responsibility, with their carriers. It's taught as practical legal ethics. I encourage questions. Please feel free to raise your hand and Andy will get the question to me. You can also use the chat feature to submit a question.
Hey, Bruce, you should have the ability to start your video now. I apologize.
Not at all.
There you
that's
go.
Better. Come on. Sorry to bounce everyone around for a moment. Okay. Okay. There we go. Hopefully that works. Okay. I'm Bruce Smith. I'm the ethics officer at Apperson Crump. Back in the day, I was a hearing panel member for the board in its early days. I'm the ethics officer for our law firm. I'm the poor man's Laura Chastain. Just to highlight something that Laura said, when the American Bar Association did a very comprehensive review of Tennessee's disciplinary rules and disciplinary enforcement system, we had in place the ability for lawyers across the state to call and get a 1-800 number and to get informal telephonic advisory opinions. The ABA recommended that Tennessee get rid of that. That's one of the few recommendations the Tennessee Supreme Court rejected. It is an extremely important tool for lawyers for the very reason that Laura said, that this is a way where if you have a difficult, challenging ethics question, or just want to check yourself out, you can contact the highest disciplinary authority within the state and get guidance. Doesn't mean that there's going to be a black letter law answer, but you can truthfully say that you consulted the highest disciplinary ethical authority in the state for guidance. One other thing you can do with Laura is if there's an email or a document or something that you want to discuss with her, you can send it to her and she can look at it before or as part of the conversation that you have with her. The handout that to which you have a link is same as in past years. It is intended as a desk reference to pull out and be able, or pull up and take a look at throughout the year. Again, don't hesitate to ask questions. In advertising, page 1 of the handout, the Tennessee Bar Association petitioned the Tennessee Supreme Court to adopt significant revisions to Rule 7. The proposed revisions have the twin goals of winnowing down restrictions imposed on lawyer advertising to the core requirement that lawyers not make false or misleading statements about themselves or their services, and that removing restrictions on communications by lawyers where the types of communications that are presently barred are not likely to cause consumer harm. This is based upon, the petition's based on revisions to the model rules of professional conduct that the ABA adopted in 2018, largely at the prompting of the Association of Professional Responsibility Lawyers. 2 Tennessee lawyers have had leading roles in APRL and in the ABA, Lucian Pera and Brian Fawnin. They have in the proposal retained some of Tennessee's unique restrictions, such as not being able to contact family members proactively for 30 days after a major catastrophic event, not being able to contact a person who initiates a divorce or domestic violence or order protection complaint for an existing period for 30 days in the event that unless there is already a pre-existing relationship, attorney-client, or a family relationship. It also reduces, the amendments shrink the scope of prohibited solicitation. It would allow sophisticated users of legal services to gain more information. Attorney-client privilege, there were several developments this year. It seems as if every year there is a lawyer who discloses confidential information as part of a motion to withdraw from representation. On page 2, the Wright case, a lawyer received a public censure because he disclosed confidential information in the affidavit he filed with his motion to withdraw. There's another case which we'll talk about a little bit later on as to other aspects, but a lawyer in his motion and an affidavit filed with his motion stated that the client's case was personally repugnant to him and that he could not pursue it in good faith. That resulted in a public censure for divulging confidential and privileged information. Remember in Tennessee that there is rule 1.6, confidentiality, and then there's attorney-client privilege, attorney work product protection, but also the duty of confidentiality. And the duty of confidentiality in Tennessee is stronger than the duty of attorney-client privilege. Pagliara versus Pagliara. It is an opinion that came out in June. A divorce attorney met with her lawyer and insisted that her friend stay in the room. The lawyer correctly informed her that their conversations would not be privileged with the client's friend being in the meeting, but she insisted that she remain. The client wanted to know whether or not she should report her husband's conduct to law enforcement. The lawyer said that she needed to talk to a lawyer more experienced in criminal law and referred her to a second lawyer who practiced criminal law. The client and her friend went to the second lawyer where the same scenario played out. The lawyer warned the client that the conversations would not be privileged and that as long as the friend stayed in the room. The lawyer told the client that the only way she could get leverage on her husband in the divorce action was if the conduct was reported. It was reported to the Franklin Police Department. The the husband filed suit against the wife for intentional and infliction of emotional distress, negligent infliction of emotional distress, and moved for production of all of the communications between the lawyers and their client pertaining to what the reporting of information to the police department. They also served a subpoena ducis tecum on the wife's law firm for any records pertaining to that. And before the trial court and on appeal, wife conceded that none of her conversations at which the client's friend was present were protected by attorney-client privilege. And again, the court emphasized that both lawyers did the right thing in informing the client, apparently at several meetings, that if the friend was in the room, the communications would not be protected by privilege. The trial court ordered production, the wife of everything. The wife appealed and argued that only the conversations at which the friend was present should be subject to production of information by herself and the lawyers. The middle section correctly said, in my view, that the problem with the wife's position was that the privilege belonged to her. She was asserting the privilege. She had the burden of establishing attorney-client privilege, one aspect of which is that that steps were taken to maintain the confidentiality of the communication. The wife was unable to establish which meetings the friend attended and which meetings the friend was not present. So they ordered, the court affirmed the decision on slightly different grounds that the communications between the wife and her attorneys and documents in the attorney's possession pertaining to reporting husband's conduct to law enforcement were not subject to attorney-client privilege or confidentiality. And mentioned on page 2 of your handout is the doctrine. It's called the subject matter waiver doctrine. The husband, it was adopted in Illinois, and it was the husband's position in the trial court and adopted by the trial court. And essentially, it says that if privilege is waived as to a particular subject matter, then everything pertaining to that subject matter privilege is also waived all the way through. The Court of Appeals said it was not necessary to determine whether the subject matter waiver doctrine applied in Tennessee. Attorney's fees, a lawyer failed to, on page 3, a lawyer failed to adequately communicate to the client the terms of her fee agreement. She then applied to the court for payment of her attorney's fees in an amount far in excess of the outstanding amount previously provided that she had previously provided to her client. Then she also failed to notify the court in the application or at hearings that their client had paid her already a portion of the legal fees that were she had submitted in her fee application. The court approved a significant portion of the lawyer's fee request. The client retained new counsel and claimed a portion of the fees which were ordered to be paid to the lawyer. And the lawyer received a public censure. That's the Washington case. The Jones case, the client signed a fee agreement that says that the $2,000 fee is a flat fee, but did not say that the fee was non-refundable. The lawyer was late to court, smelled of alcohol, acted erratically, and was removed from the courthouse by court personnel charged with public intoxication. By email later that day, the lawyer agreed to provide his client a full refund. However, over the next 2.5 years, the lawyer made 3 partial reimbursement payments totaling $1,650. The lawyer didn't keep the fee in his trust account. He received a public censure with a condition that he refund $350 to his client within 60 days. The Krennis case, also on page 3, lawyer was paid a portion of a non-refundable fee, but failed to provide legal services until the full amount of the non-refundable fee was paid. He also charged other fees that were unreasonable, and later changed the scope of the representation and increased his fees without obtaining, and it should say without obtaining, the informed consent of his client in writing, or as an alternative, giving his client the opportunity to meet with independent counsel. The lawyer received a public censure. He also failed to communicate, file any other pleadings, or make court appearance. That's the Krennis case. The bottom of page 3, top of page 4, a discussion of Abner versus Abner. This was a divorce in which the wife owned a convenience store in Mexico, which she sold prior to the marriage. After she moved to the United States, she transferred $32,000 to $34,000, the net sale proceeds, to the Oak Ridge National Credit Union. Then she transferred the money into a sub account. Her first testimony was that she transferred the money into a sub account of the party's joint account on a subsequent, which raised the question of transmutation. On a subsequent day of trial, she testified she'd been mistaken and had transferred the funds into a separate account solely in her name in March 2009. She was cross-examined. She admitted that at her deposition, she testified that the money was transferred sometime between 2002 and 2005. The trial wound up taking 5 days. The judge in his ruling felt that the wife had no legal basis to argue the classification of property that the husband inherited changed due to a will contest. Husband paid $80,000. When he got his inheritance, he repaid the $80,000 into the account. The court was also very troubled by the wife changing her testimony after her deposition as to when the money previously located in Mexico had been moved to a bank account in the United States. So the court assessed the attorney's fees for 4 of the 5 days of trial to wife as a result of her unreasonable arguments. The Court of Appeals reversed, saying that Rule 11 allows for award of attorney's fees as a sanction. The Rule 11 procedures were not followed. There was no basis for the court to award 4 of the 5 days attorney's fees, husband's attorney's fees, as a because of the wife's unreasonable arguments. On page 5, the top, Richardson, a non-refundable fee. The lawyer failed to obtain a written agreement signed by the client confirming the fee was non-refundable. The lawyer received a public censure. That's one of the categories in which there has to be a written fee agreement signed by the client. The Frazier case, a lawyer improperly shared a fee with an attorney outside his firm without obtaining the written consent of the client. It violated Rule 1.5E. The difficulty is that if you associate counsel and are going to pay a portion of a fee to the other counsel, the client has to consent in writing. This is the Frazier case. The lawyer received a public censure with a condition that the lawyer reimburse $2,500 to the client within 90 days. Note that as a matter of disciplinary process, that this is a significant change that disciplinary counsel and hearing panels now have. There are conditions that can be imposed to public censures and to suspensions. In this case, it was a condition that the lawyer reimbursed $2,500. It was paid to the lawyer outside the firm without written consent of the client. The Roberts case, in the middle of page 5, a lawyer enlarged the scope of his legal services and altered the terms of his fee agreement without adequately communicating with his client. Things change from when the client first walks in the office and when the engagement agreement or the attorney fee contract are signed. But if the scope of the services or if the billing arrangement is going to be changed, that has to be adequately communicated with the client before it goes into effect. Here, the lawyer later claimed an interest in funds that were paid into court for the benefit of the client. The lawyer, there was a dispute between the attorney and the client. The lawyer's relationship with the client ended, and there was a hearing. The court issued a final order denying the payment of any funds whatsoever to the lawyer, found that the lawyer failed to communicate the terms of his amended fee arrangement with his former client, and failed to set forth the new terms of his fee in a writing signed by the former client with the opportunity to seek advice of independent counsel. The Wanyu case at the bottom of page 5, the lawyer raised claims in the civil proceedings which had no factual or legal basis and failed to withdraw the claims after he determined that the claims could not be supported. The lawyer also failed to keep the client informed of the fees he had billed during the representation, and many of the fees were unreasonable based on the amount of time charged for simple and administrative tasks. A lawyer cannot charge lawyer rates for work which is properly for support staff or paralegals to perform. The lawyer received a public censure with a condition that he is prohibited from seeking payment for any outstanding balance owed by the client. There's a case that is not in your handout material. It is called Mr. Appliance LLC versus Appliance Services of Tennessee LLC. A franchisor sued a franchisee in Texas and obtained a default judgment, and then filed a petition under the Uniform Enforcement of Foreign Judgments Act to enroll the judgment and be able to enforce it in Tennessee. The franchisor moved for summary judgment. The Tennessee franchisee argued that there was a genuine issue of material fact as to whether it had been served in Texas. Trial court granted the Texas franchisor's motion for summary judgment, entitled and ruled that the Texas judgment was entitled to full faith and credit, and awarded the franchisor over $26,000 in attorney's fees as a matter of equity. The fees were incurred to enforce a valid judgment. The court ruled, the Court of Appeals ruled that there are some exceptions to the American rule, which means that each side pays their own attorney's fees unless there is a statute or contract provision which allows for collection of attorney's fees. But there was nothing for under the Uniform Enforcement of Foreign Judgments Act that permitted this court to award attorney's fees on the basis of equity. So the summary judgment for enforcing the judgment was affirmed. The award of attorney's fees was set aside. There's also another opinion from the Court of Appeals, Sexton versus Carden, Carden, decided on December 9. It contains it's a domestic relations matter. There is a very good discussion as to who is a prevailing party and what it takes to be considered a prevailing party for purposes of awarding or obtaining an award of attorney's fees. This was in a domestic relations context. The husband in this case was ordered to pay attorney's fees. He argued that the wife could afford to pay her own attorney's fees and he could not. The Court of Appeals did not adopt either argument that the husband attempted to advance. Worth a few moments of your time if you have that type of circumstance. Attorney-client privilege and confidentiality. On page 6 of your handout, we've already talked. This is the Yanwanyu case where the lawyer revealed confidential information in his motion to withdraw by stating that his client's claims were personally repugnant and could not be defended. It received a public censure. The Wright case is a lawyer who disclosed confidential information in his motion filed with his motion to withdraw. Judges understand that if a lawyer is moving to withdraw, and if you state in your motion that the withdrawal is required by the Tennessee Rules of Professional Conduct, rule whatever, and whatever other grounds you have, the court understands that it cannot say, well, let me inside your file. Tell me really why you need to withdraw. They understand that there are ethical requirements which lawyers have to fulfill, and that sometimes the relationships break down, and that the lawyer has no choice except to withdraw, and that in so doing, the lawyer cannot tell all to the judge. Bankruptcy, a lawyer represented a homeowner in a detainer action initiated by a mortgagor, filed 4 successive Chapter 13 bankruptcy petitions, all of which were dismissed by the court after the lawyer made no further filings after filing the Chapter 13 petition. The lawyer received a public censure. He violated Rule 3.1, which is meritorious claims and contentions. The petitions weren't meritorious and were filed to improperly stop execution on valid writs of possession. The Boykin case, also on page 6, lawyer was retained to represent a client in a bankruptcy, never filed a bankruptcy petition, but led his client to believe that a petition was filed and then stopped communicating with the client. That lawyer received a public censure. Conflicts of interest, a very good resource cited at the bottom of page 6. Freivogel on conflicts. It's a guide to conflicts of interest. It is updated very regularly by Mr. Freivogel. Numerous subtopics. It's a great resource if you have a conflicts question. Business dealings with clients and friends. A lawyer engaged in a business transaction with a client and a friend without properly informing them of the conflict of interest. The lawyer was suspended 1 year, of which 3 months is active suspension, the remainder on probation, ordered to meet with a practice monitor monthly. On page 7, the lawyer's personal interests and financial interests conflicted with those of his client, a limited liability company. Essentially, the lawyer is the sole member of an LLC, which in turn is a member of a second company named FYI. And the lawyer was appointed by resolution as the attorney for FYI for particular issues. So the lawyer hired an attorney and filed an involuntary bankruptcy petition against FYI in his role as sole member of the other LLC. On the next day, the lawyer filed a notice of appearance in the bankruptcy as a pro se creditor of FYI, alleging that FYI owed him a debt personally. The lawyer violated Rule 1.7, conflict of interest, 8.4D, prejudice to the administration of justice, and received a public censure. The Thompson case, Laura, on bottom of page 7, Laura's talked about. The Culpepper case is discussed at the bottom of page 7 and the top of page 8. This is an opinion that's worth a few moments of your time. Mr. Culpepper was the former CFO of a pharmaceutical company and later became the interim CEO. The firm and its very senior leaders had a very serious matter that became active with the Securities and Exchange Commission. They hired a law firm. The law firm represented the company, Mr. Culpepper, and several other senior leaders. Quoted at length in the opinion is a very comprehensive and very well-written conflict waiver that Mr. Culpepper signed. He acknowledged that freely and voluntarily that information that he provided to the law firm would be provided to the company and the other individual clients the firm was representing, that the other individuals may provide confidential information to the law firm, but they would not necessarily provide it to him. Waived any past, present, future conflicts. It discussed in detail the benefits of joint representation and the possible risks of joint representation. The client signed the letter on August 31, 2016. In December 2016, the lawyers met with the employer's board of directors, and Mr. Culpepper was terminated. At that point, his representation by the law firm ended. He later found out that the law firm had met with forensic accountants on August 15, 2016, about 2 weeks prior to him signing the conflict waiver, and never disclosed that meeting or its contents to Mr. Culpepper, either before he signed the conflict waiver or after or before he was terminated in December 2016. He filed a legal malpractice lawsuit. The law firm and its lawyers filed a motion for judgment on the pleadings, relying on the signed conflict waiver. This opinion gives a very good discussion summary of whether a violation of the Tennessee Rules of Professional Conduct creates civil liability. The answer is it does not, but it could be evidence, relevant evidence of a deviation from the applicable standard of care. In this case, the Court of Appeals reversed the grant of summary judgment to the defendants, stating that the undisclosed meeting may have violated Rule 1.7, and the case was remanded for further proceedings. Page 8, every year we discuss, unfortunately, criminal convictions of lawyers for various offenses. Again, the purpose of this is that in each of these matters, there is a victim and often a lawyer representing the victim or other persons affected by the criminal conduct of the lawyer. Starting at page 9, violation of an order of protection. A lawyer had a jury trial. Ultimately, the lawyer and was found to have violated the order of protection. She received a public censure. Simple assault by offensive touching, the Dempsey case. The lawyer was entered an offered plea to a Class B misdemeanor. The lawyer was suspended for 5 years, 3 years active suspension. He was also suspended by 3 years for the U.S. Bankruptcy Court for the Western District of Tennessee for misappropriating funds, improper trust accounting, making misrepresentations to his client in the court. Rape and kidnapping. A lawyer was indicted. He was charged with multiple counts of rape after a Tennessee Bureau of Investigation that alleged that he forced or coerced female clients into sex as a way to repay their legal fees. In a separate matter, he was charged with aggravated rape and aggravated kidnapping of a teenager who was babysitting his daughter after she returned home. It should be home. The teen was able to escape and call 911 when the lawyer failed to appear for an early hearing. A bench warrant was issued for his arrest. He was located in another state, and when law enforcement approached him, he killed himself. Theft over $10,000, official misconduct, tampering with government records, and computer offenses. Prosecutor was indicted for wrongfully obtaining salary and travel payments back to 2017. The lawyer was paid for military leave when he wasn't on military orders or drill status with the U.S. Navy. Was paid an additional sum for 16 days of military leave after he'd already used the number of days permitted by state policy. Also was paid for annual leave and sick leave that he did not have. Theft of $25,000 or more. Lawyer was convicted in Louisiana. Tennessee imposed reciprocal discipline of permanent disbarment, the new feature that Laura mentioned earlier. Suborning aggravated perjury and 2 counts in criminal simulation. There's a discussion on the bottom of page 9, top of page 10. Family lawyer representing the wife in a divorce signed her name to an ex parte emergency petition seeking to prevent her ex-husband from exercising his visitation with their children. His client testified that the day after a hearing, the defendant called her, seemed upset and aggravated, and asked, "Don't you remember giving me permission to sign your name?" She also testified that the defendant told her that attorneys signed documents for clients frequently and that he might get a minor reprimand, but there would be no harsh punishment because the contents of the affidavits were in fact true. He told her to testify at the next hearing that all of the signatures were in fact hers. However, the client's employer testified that the client was at work when she was supposedly at the lawyer's office signing the petition and supporting affidavit. A handwriting expert testified that the signatures were not that of the client and appeared to be in the defendant's writing. That's the Dahl case. Criminal law, the Court of Criminal Appeals on page 10 rejected a post-conviction relief petitioner's argument that she was entitled to a second post-conviction relief hearing because post-conviction counsel was suspended from the practice of law shortly after the post-conviction hearing. The petitioner didn't suffer any prejudice. The lawyer was licensed at the time of the events in the petitioner's case. The Thomas versus State. Thompson case, also on page 10, an assistant district attorney general made several inappropriate comments during her opening statement and closing argument in a criminal trial that were clearly impermissible and prejudicial to the defendant. She received a public censure. Her conduct negated the defendant's right to a fair trial. The case was reversed on appeal for prosecutorial misconduct, which meant that the matter had to be retried. The Waldman case, also on page 10, a lawyer failed to timely file a motion for a new trial after sentencing of a criminal defendant. The trial court lost jurisdiction over the case. The lawyer failed to protect his client's interest by requesting permission to late file the appeal. The Tennessee Bar Association, at the bottom of page 10, top of page 11, filed a petition to amend Tennessee Supreme Court Rule 13 to provide for interim billing for appointed counsel for indigent parties in non-capital cases. This was the heavy lifting done by appointed lawyers who were hit particularly hard during when COVID hit in very early 2020. The court was sympathetic, but said it would need additional funding, and unfortunately for these lawyers, no relief was provided. In page 11, at least 8 lawyers were disciplined for failure to respond to a disciplinary complaint. If a complaint is filed, it is a very simple thing to get an extension for filing the response from disciplinary counsel. Even a second or a third extension. Request the extension before the deadline expires, and disciplinary counsel is very professional and very understanding of circumstances, and will grant extensions, not on an unlimited basis, but there's the idea of getting a response filed is so critical that disciplinary counsel will grant extensions so that that can be done. At least 3 lawyers were immediately temporarily suspended that he or she misappropriated funds. A case on the Graham case on page 11, top of page 12, a lawyer was temporarily suspended, finding that he had misappropriated funds, posed a threat of harm. This was a matter where there were a lot of expenses to be advanced and paid, and there appeared to be a legitimate disagreement or question as to $9,000, whether there was a math error. The lawyer filed a petition to dissolve the temporary suspension. The lawyer paid certain invoices of the expert, but the expert did not in turn pay the expert because the client had not paid all of the monies due to the respondent. There were also emails which the lawyer exchanged with the client, which the lawyer said, if you pay X dollars, I will in turn pay the expert. Only a partial payment was made. The hearing panel found and recommended that the temporary suspension not be dissolved, and the Supreme Court agreed. It was clear that the respondent intentionally misappropriated client funds that were intended to be paid to the expert. The lawyer did establish that he did not pose a threat of substantial harm to the public, but the court did order that the temporary suspension remain in place. The idea that the lawyer knew that he had funds that belonged to the expert in his trust account and did not disperse those funds was a very important factor. Bottom of page 12, top of page 13, the rule amendments. Laura talked about several of those. The on page on starting discipline, starting on page 13, a lawyer consented to permanent disbarment because she couldn't successfully defend charges alleged in the disciplinary complaints. Immigration attorney was paid but failed to complete legal services. She was disbarred. In a separate matter, the Lawson case, a lawyer in 5 separate matters failed to appear in court to provide legal services for which he'd been paid, failed to refund unearned fees, misappropriated the fees, and misappropriated funds in his trust account. He was permanently disbarred and ordered to pay $67,850 in restitution. You can look at the immediate summary suspensions on page 14. A lawyer at the bottom of page 14 was an improper partnership with a non-lawyer, failed to deposit retainer fees into a trust account. He was suspended for 2 years. Lawyer who converted settlement funds to his personal and business use, and who during the course of the investigation falsified bank records to prevent discovery of the misappropriation, was suspended for 7 years. He also failed to promptly pay third-party lien holders, failed to keep estate funds and client funds in a trust account. The lawyer entered a conditional guilty plea to a 7-year suspension, 5 years of which is active, and the remainder on probation. A lawyer, the Teets case, a lawyer assisted in the incorporation of a nonprofit in exchange for being named treasurer, admitted that he misappropriated funds from the nonprofit while acting as its treasurer. That lawyer received a suspension. The Smith case, the bottom of page 15, a lawyer lied under oath in a deposition in a child custody matter in which she was a party. In her deposition, the lawyer lied in her response to 6 questions as to her use of alcohol in the presence of the child. She received a public censure. A mitigating factor was that her conduct was not done in the representation of the client. The lawyer admitted her conduct under oath in her trial testimony. As a condition of her public censure, she must schedule and complete an assessment with the Tennessee Lawyers Assistance Program. The impaired lawyers and judges, there are several cases starting at page 16 of your handout. Lawyer who admitted ethical violations as to 3 clients was suspended for 2 years, 45 days of which is active, the remainder on probation, to be evaluated by TLAP and engage a practice monitor. She abandoned her client's case. In a second matter, she took no action after having been retained. The Elsie case on page 17, a lawyer deceived his client into believing the settlement had occurred and deceived the court clerk and opposing counsel as to the true status of the case. That interfered with the timely administration of justice. The lawyer received a public censure. In mitigation, the lawyer was experiencing personal issues that caused him undue stress and anxiety, which the lawyer's currently addressing. There is in other cases, which you'll see, lawyer abandoned his client's case, suspended for 2 years, must undergo a TLAP evaluation. The Perry case, a lawyer failed to distribute funds to multiple clients following settlements, failed to distribute funds due to lien holders, 6-year suspension, 4 years active, remainder on probation. The Moore case, judicial discipline. Lawyers and judges are being disciplined, and the Board of Judicial Conduct issued a public reprimand to a judge who made an inappropriate comment to a courtroom audience consisting of criminal defendants, some of whom were African American. The statement was, the grand wizard of our Supreme Court said we have to wear these masks. He tried to explain to the Board of Judicial Conduct that his words were intended to soften any resistance by persons present in the courtroom to the requirements of wearing a mask because he had received negative feedback to the Tennessee Supreme Court mandate. He agreed the comment was wrong, cooperated fully, and strong language on page 18 of your handout. It's the Ledsinger case. Another COVID case by a judge on page 18, page 19. The Hinson case just came out this week. Judge failed to abide by the COVID-19 restrictions. His courtroom on many occasions was filled to capacity, sometimes with persons standing shoulder to shoulder around the walls. He made a comment in open court that he wished that Chief Justice Jeff Bivens would win an award so that the COVID-19 mandates from the Supreme Court would end. He received a public reprimand. He was told that there's no choice. The COVID mandates are court orders. They apply to all courts and all judges, including him. The language of the reprimand is on page, in an excerpt on page 19 of your handout. There are many cases of judicial disqualification and recusal, beginning at page 19 of your handout, going to page 24, which you can take a look at. There are several main ones. One, the Cook case, a post-conviction judge was obligated to recuse himself, even though petitioner didn't file a motion for recusal under Rule 10b. The judge said that he knew the two trial lawyers, criminal defense lawyers, very well. It was in a post-conviction setting, and that each of them were preeminent lawyers in Memphis, in Shelby County, in Tennessee, in the United States, in the world. How could anyone claim that either of these lawyers provided ineffective assistance of counsel? The Tennessee Supreme Court felt that these comments and the judge's comments that he disagreed fundamentally with Tennessee's post-conviction relief procedure, and that it was a game which had to be played, deprived the post-conviction petitioner of an impartial jurist deciding his petition, and also said this raises the question as to whether this particular judge should be permitted to hear any further post-conviction matters. There was an admonishment to all trial judges, which is on page 20 of your handout, that says that, which makes it very clear that a judge who, if the court determines that a judge has habitually made inappropriate comments that call into reasonable question the judge's impartiality in a particular category of cases, this court will not hesitate to hold in the exercise of its supervisory power of the judicial department the judge is disqualified from hearing all future cases in that category. Unhappiness with trial judges' rulings, not a basis for disqualification. The procedural requirements of Rule 10b have to be followed very strictly. It's an expedited process. The appellate courts stick to the schedule. So you'll see where failure of a Rule 10b motion to state that it's not being presented for any improper purpose, that's ground for denial. The end of a first day of a two-day trial, trial court told the petitioner that based on the pleadings he'd read and the proof he'd heard to that point, he thought the petitioner's case was ridiculous and encouraged the parties to discuss a settlement, a resolution. That was not a basis for disqualification. There's another case. I'm sorry, that's the Niamtu case. The basis that the chancellor formerly employed and directly supervised a guardian ad litem that had been appointed, former paid law clerk, that's not a basis for disqualification. And an attempt to argue that the motion to that the trial judge may be a material witness was not a sufficient basis for disqualification in the Hill-Boren case. On page 24, after multiple attempts to have the judge recuse himself, came to the Court of Appeals and was remanded back. The judge denied the motion, but then said that his wife was a teacher at the school where the children who were the subject of the post-divorce action were students, that she was a material witness, and that he therefore on his own motion was recusing himself. He then said that the new judge would have to have the benefit of the 2 days of trial proof that had already been completed. And he ordered the husband who had filed the motions to recuse to pay the cost of the preparation of the trial transcripts. This is the Dougherty case on page 23, top of page 24. The court affirmed the recusal, but said that Rule 10b prohibits entry of any further orders after recusal by the recused judge, and set aside the order that the father pay for the cost of the trial transcripts. The Henry C. Ellis estate case on 24 is worth a look. There's a very good discussion of the distinctions which are significant of transfer of a case to another court and hearing a matter by interchange. In this particular case, the probate court judge transferred the case to a circuit court judge who then conducted hearings. The difficulty is, according to the Western section, that Rule 10b expressly prohibits the judge who recuses himself or herself from appointing or designating a successor. And so all orders, when the case had gone on in circuit court for some time, entered after the recusal, after the judge recused, your probate judge recused herself, were vacated. The legal malpractice, there are a couple of cases. The Rosen versus Wolf Artist case was a matter that came out late last year, which we did review very briefly and orally, and it basically the lawyers were sued for legal malpractice for failing to renew judgments. The Court of Appeals said that the clients had knowledge or were on inquiry that the judgments needed to be renewed, again, within 10 years after the effective date of the judgment. And for that reason, they held that the lawsuit was filed outside the statute of limitations. In litigation, the Alaska matter, a lawyer threatened to file a disciplinary complaint against a non-party attorney in order to gain a tactical advantage in his own divorce. He sought written discovery by issuing a subpoena to third parties in his own divorce and informed a third party that they could face criminal action if they failed to properly respond to the subpoena. That lawyer received a public censure. The delay in transmitting settlement funds in a lawyer's trust account to a medical provider who claimed a subrogation interest, received a public censure. The Johns case at the bottom of page 26, a lawyer told opposing counsel to sign her name to an order without providing a copy to her client for review. In this matter, the lawyer was hired to defend a contempt petition, which alleged that the lawyer's client had sent text messages to a neighbor in violation of an order of protection. Prior to any evidentiary hearing, the lawyer recommended that her client settle by paying the neighbor's lost wages and attorney's fees. There was no documentation, but the agreement was supposedly in an amount up to $5,000. Both lawyers thought an agreement had been reached, but over the next 2 weeks, the client sent Ms. John, the lawyer, 2 texts and an email indicating she did not believe the matter had been settled. The order was actually for $5,500. That lawyer received a public censure. Page 27, Bearden versus Ballard Health. This is a merger case of two healthcare providers. The Sixth Circuit, arising out of the Eastern District of Tennessee. There's a very good discussion here, and wish we had time to review it. But basically, the appellant's counsel made statements that the other entity surrendered in the same to the bigger entity in the same way that Marshal Pétain surrendered France to Hitler's Germany. There were that Ballard and MEAC, the other, are intertwined in an incestuous relationship, the likes of which have not been seen since Sodom and Gomorrah. That the Tennessee Department of Health's failure to supervise the defendants is akin to the Tennessee Bureau of Investigation, allowing criminals to rape, murder, pillage, loot, and plunder on its watch while agents stand by. The defendants challenged this language as disrespectful. The plaintiffs doubled down, comparing one of the individual defendants who had stuttered during a television interview to Porky Pig, a famous Warner Brothers cartoon character who also stuttered. The Sixth Circuit didn't like this litigation approach at all, and had some very forceful language, which is on page 27 of your handout, as to the good reasons not to disparage your opponent, especially in court filings. Asserting only meritorious claims, we've already talked about. The attorney was disciplined for failing to withdraw claims after he determined that they were not founded in law or in fact. A lawyer was disbarred on page 28, Dunn case. A lawyer admitted that he assigned 19 client files to associates within his firm, that when the associate left the firm, the file stayed with the firm, but nothing happened. The lawyer failed to work the client's file. In 12 other matters, the lawyer participated in a timeshare relief program that didn't provide any relief to complainants. The lawyer was disbarred in order to pay over $95,000 in restitution. Arizona has become the first jurisdiction to permit non-lawyers to hold an ownership interest in a law firm. There's a citation to that order on page 28. There are 2 new ABA formal opinions other than the one Laura mentioned. Again, they're not binding in Tennessee unless the Supreme Court or the Board of Professional Responsibility say that they do stand as authority in Tennessee. Formal opinion 489, obligations related to notice when lawyers change law firms, and then formal opinion 491, there's a typo in the second line at the top of page 29. Obligations to avoid counseling or assisting in a crime or fraud in non-litigation settings, the crime fraud exception. The personal security and electronic security, very quickly as we end. Lawyers are targets for cyber criminals, for hacking, for phishing. Lawyers are keepers of the secrets. Follow Laura's advice. Passwords. I heard the head of the FBI cyber attack team, who is very busy right now dealing with Russia, but use an event, make it long. West Tennessee with Lewis and Laura, DEC 18-2020. something that means something to you that won't forget, mixture of numbers. It can be an event, something you did. Examples of cybersecurity include the Middle District of Tennessee being victimized. U.S. District Court was victimized by a telephone spoofing scam on page 30. On real estate, lawyer filed a petition to quiet title and termination of a cemetery, delegated to a non-lawyer the responsibility of contacting descendants of the family, it's a family cemetery, and publishing a notice of the petition in the Nashville Ledger without communicating directions to reasonably assure the non-lawyer's conduct was compatible with the lawyer's professional obligations. The lawyer then misrepresented to the court that the petition to quiet title had been served by publication. In fact, the notice had not been published. The lawyer also misrepresented to the court that a descendant of the family buried in the cemetery had agreed to reinter the bodies at Perpetual Care Cemetery and obtained a default judgment on that basis. It was no longer true. The lawyer received a public censure. Sex with clients, staff, and litigants. There's a reference to a newspaper article on page 30 and 31. Trust accounting. A lawyer failed to timely remit employee deferred contributions and matching contributions to the firm's 401k plan. Lawyer entered a conditional guilty plea and received a public censure. And on page 32, the Maloney case, Laura talked about the change in the IOLTA rules. In this case, a lawyer was suspended for 18 months, 10 months of which was active, for failure to escheat funds to the state using funds held in escrow for his business and personal use and to timely disperse funds owed to third parties. Unauthorized practice of law. Very quickly, lawyer moved to Nashville and with his application for comity admission to practice in Tennessee pending, filed pleadings using a signature block with his name followed by his supervising attorney's BPR number. Again, you're not licensed in Tennessee until you are licensed. The Cassis case, lawyer licensed in Florida and New York, accepted corporate counsel position in Tennessee without timely registering with the Board of Law Examiners, the Board of Professional Responsibility. We're a few minutes over. Thank you very much for your attendance today. Andy, do we have any questions?
There are no questions in the chat box. Bruce, thank you so much for doing this. Thank everybody for attending. Just a reminder to fill out your CLE form that's in the Dropbox link in the chat, and that has been emailed out to everybody. And please get those to me as soon as you possibly can, but at the latest December 28th, so I can get those submitted for everybody's CLE credit. I hope everybody has a good rest of your day, a good weekend, and a good Christmas. Thank you all.
Thank you.